So hello everybody. Today in this video, I'd like to talk about the Article 28 of CIG, which specifies that if when one party is entitled to require performance of any obligation by the other party, a court is not bound to enter a judgment for specific performance unless the court would do so under its own law in respect of similar contracts of sale not governed by the CIG. With respect to Schlechtram and Schwetzner commentary on the article of the CIG, they highlight the compromise between the civil law, which generally allows for specific performance as a remedy, and common law, which primarily favors damages. And the article permits court to refuse the specific performance based on their own domestic laws, reflecting a balance between the harmonizing international sales law and respecting national legal principles. But it is practically important is limited since the economic interest in specific performance often aligns with both legal traditions. Another commentary that I found would be from Björklund, and he emphasizes the compromise between the common law's preferences for damage and civil law's preferences. So as far as the Schwetzner and the Schlechtrein, but despite concerns about the potential foreign shopping, practical application has shown minimal controversy, partially because cases don't demand performance and because the CIG itself limits specific performance making in the Article 28, the impact largely theoretical. And the last commentary would be from Enderlein in Moscow. So they also compromise between civil law's preference and specific performance of the common law. But they noted that while the CIG grants the right to specific performance, practical limitation and the obligation to mitigate loses often, and the alternative remedies and the change from could to would in the text reinforces courts' discretion in granting specific performance. So with respect to cases, the first case happened in the Northern District of Illinois, in the district court. The party's name was the Magellan International Corporation versus Salzgitter Handel, where the court ruled that the plaintiffs complaint sufficiently allege the contract, anticipatory repudiation by defendant, and damages resulting from the repudiation. The contract also found that under the Article 46, the Provision 1 CSG, supported by the Article 28 of the CSG, specified performance could be ordered, emphasizing the role of Article 28 and in line with the CIG remedies. The Article 27's importance lies in the broader context of communication, through it wasn't directly highlighted in this case, but is the court focused on the substantive provision regarding to the performance and remedies. The second one case happened in Florida. The names of the party was the Styles versus Movie Star Muscle Cars, happened in 2017. And the court ruled in the favor of the buyer, granting specific performance for delivery of unique anti-Q car. And the Article 28 CIG played a crucial role in the court's decision, as it required the obligation of Florida law to determine the appropriateness of effective and specific performance, aligning the CIG remedies with the domestic legal framework. And with respect to third case, happened in the International Arbitration Court of the Chamber of Commerce and Industry of the Russian Federation. So here the parties from Russia and Germany companies regarding to the contract for the sale of metal produced, the metal products. The arbitration tribunal applied the CIG, but also referenced the UNIJOY principles due to the absence of specific requirements for specific performance in both like CIJ and Romanian law. Okay, thank you so much.